Hello, this is Vinod Bange from Taylor Wessing. Welcome to our webinar today. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection issues. And I can see that there are regular attendees that have dialed in today, and you'll be very familiar with some of the previous topics that we've looked at in our webinar program. And we've looked at challenges, as you'll know, such as workplace and employee, GDPR and data protection issues, looked at some of the thorny issues around topics such as direct marketing, ad tech, and more recently, we've also been looking at topics such as Schrems 2, and also newer developments such as the standard contractual clauses, all topics that have kept data and privacy pros working very, very hard indeed. Now, recordings of all those webinars are available if you missed them. In fact, there's over 30 plus webinars if you want to access those in our virtual learning bank. Today, we're going to be continuing on the theme, looking at a topic that we first looked at in 2020. And again, we looked at it in March 2021. And that's the topic of today. It's a children's code. And it's a children's code because it's come of age. And today, we're going to recap on a few points of what we looked at before. And then we have a special guest. And we're going to have a conversation with the Information Commissioner's Office. Now, it's been some 2 years in the making, this code, and probably longer, in fact. And over a year ago since the ICO published the Age-Appropriate Design Code, the title of which has now evolved into the Children's Code. And today, as I say, we're going to look at this again. And now the code is fully in force. And as I said, it's come of age as of the beginning of the month. And I'm delighted that we have a special guest speaker with us today. We are joined by Jacob Ohrvik-Stott from the Information Commissioner's Office, and I will introduce Jacob in more detail shortly. As always, delighted to welcome new attendees today as well. And so for those of you new to this webinar series wondering who Taylor Wessing actually are, you will see very soon that we are a leading international law firm. I'm not going to go chapter and verse into who we are, but you'll see from the slides at the end and those slides that we distributed that we are a leading law firm. We're an international law firm, and we advise clients in local and international markets in full service law firm offering. And we are very much also a dedicated and specialist global data protection practice. And it is through that data protection and cyber practice that we bring you today's webinar. So what are we going to be looking at today? And it's just a very outline agenda that we have for you, and then we'll start to dig into that in just a moment. The introduction, which I've already really started, is, as I say, looking at the topic of the moment. It's the Children's Code. And what I'm going to start off with is just looking at some readiness polls. And these are not necessarily brand new readiness polls as of today, but we thought it's interesting just to take a moment and look back at the webinar that we did 6 months ago. So that was our T-minus 6 months webinar, looking at readiness, looking at some of the thornier questions that we're seeing at the time around readiness, and also some of the aspects of the Children's Code and how to go about dealing with some of those points. And we looked at that in the last webinar. So in a moment, I'm just going to recap on some of the findings of those readiness polls as we saw them back then. Naturally, we would hope that things have moved on somewhat, but we'll see that as we look through the polls. And then what we're going to do is then we're going to hear from our key speaker today, and Jacob will be talking to us about quite a few different elements, which he'll explain in his agenda slide very shortly. So why don't I move on without further ado and just look at some of those readiness polls so we can move on as soon as possible to bring our key speaker into play. So in our T-minus 6 months webinar, we asked a question and we looked at the issue of, and it's quite a broad question, but do you think the AADC will actually apply to your business? And interesting, we looked at this twice during the last webinar. We asked it straight at the beginning, and then we asked it at the end as well. And deliberately trying to gauge whether or not any one of your answers in those areas had changed or changed significantly. And this is the question that we asked at the end, from which you'll see that a significant amount of you thought that yes, the code, the AADC is highly likely to apply to you. A smaller percentage were not sure, and a small but noticeable percentage thought that there was a low chance that it does apply, but you needed to know more about it at the time. And what we did see is at the start of the webinar, this is the results as we finished at the end of the webinar, but at the start, there were more people in the not sure category, and there were more in the, we think there's a low chance that it applies to us, and we need to know more. But what happened is the blue slice of the pie, that yes, this is highly likely to apply, increased in your responses at the end. So from that perspective, we hope that the webinar served its purpose in terms of allowing you to understand a little bit more around how this applies. And for those who were in that category of not sure or really not knowing where this really hits home for you, that you then learned more and understood that, yes, this is something that is highly likely to apply to your business. And then we started to just dig a little bit deeper, and particularly for any piece of law or regulation or something as certainly as wide sweeping as the children's codes, trying to understand the status of awareness amongst your key stakeholders within your business. And this is crucial for so many programs and so many regulatory regimes before they can really level up and become compliant, is to make sure that your stakeholders are fully aware of what's required and make sure that they're there to support and champion what you're actually trying to do. And in that particular question, you'll see what the answers look like. There was a fairly vast, but 65% of you felt that your stakeholders were partially aware, but much more engagement and awareness is required to really make sure that they were more engaged and more fully aware of what the code is all about and how it impacts on the business. A smaller but more noticeable 20, almost 25% of those who polled at the time, and yes, they have been fully engaged, and that's fantastic to see, but still a relatively small proportion compared to those where they were saying it was only 65% partially aware. Surprising in some ways, but a 12% of you felt that you were just not sure. You just didn't know whether your key stakeholders at the time were engaged. And what this shows is there was still a lot to be done in terms of many of you being able to increase the stakeholder awareness in order to increase stakeholder engagement. And remember, this is the position as of 6 months ago. Then asking the fairly blunt question, given we were only 6 months away, to just assess what your feelings are in terms of, can your business achieve compliance, given that there's only 6 months to go, and looking for the answers in that sort of relatively binary way, in that, yes, that's achievable, but we'll need a clear program of change. Or if you're just not sure, and you could see that there was a significant, almost third of you that were really not sure, but still a significant 2/3 of you that thought, yes, it's possible, but that program of change and real movement towards compliance was really going to be needed in order to get to a better position where hopefully you are today. But we know there are lots of questions, there are lots of issues still to be discussed and walked through, and we'll talk and discuss some of those shortly. We looked at whether you have conducted an assessment of your scope and the scope of your services and products, and whether they're actually caught by the code. And again, you could see that there was a mixed state of readiness, where even though it looks like a vast sort of 63% of you thought, yes, you have conducted that, the answer was yes, but only at a high level. It was a much smaller proportion where you felt that yes, but and a more detailed questionnaire-based assessment had been undertaken but behind that. So still reflecting that a reasonable degree of work was required around conducting a more detailed assessment. We started to toy on a few more areas just to gauge your understanding and thinking, particularly in areas like extraterritorial impact. And it was quite clear that those who were polled at the time were feeling more confident in understanding, for example, whether or not there was an extraterritorial impact to the code. But again, still a degree of folks who were unsure. So some technical knowledge was in existence, but still a gap of notice to fill there. We then did start to toy in some of the areas which we're going to look at a little bit later, and I know there's some questions on this point, in terms of age gating, and looked at whether or not you felt that the code required you to adopt some form of age gating. And whilst a vast number of you, something in the region of 70%, felt that you possibly did, but again, it was with the caveat that much more assessment was actually required. So even though there was a noticeable, what looks like a 25%, in fact, looking at my other face, exactly 25% of you felt that that was a definite yes. A huge majority of you thought still really need to get under the bonnet of that question and see how you can take that forward. And then finally, in the whole ending to that webinar was lined up as if it was planned, because we'd already been speaking with Jacob's colleagues about how we can come forward with a webinar, which is what we're doing today, and gauge your views also on what more the ICO can do. And when we talked about it at the time, again, you could see the results of that coming through there and see how it's quite visible for you there. You can see that a noticeable, what looks like nearly 40% of you thought, yeah, you felt that the ICO could provide more guidance in some areas, but a vast, almost spot on 50% of you there in the left-hand segment there felt that you would like the ICO to help and support and provide more specific feedback on some of the more key areas and approaches in particular to enforcement. So lots to gauge there at the time, and it showed that still many of you were in the process of understanding, digesting, still needing to do more work, to a degree feeling confident that you were able to embark on that and have some stakeholder engagement, but acknowledging that more was needed in that area. And as I mentioned, that was the second or third in the series of webinars that we'd had, looking at the code, explaining the code to you and our views on some of the areas and interpretation and application. So today, what we're going to do is deliver on the promise that we provided at the end of the last webinar, where we said we would invite the ICO to come along and present on this topic, but more importantly, give an update. And this time that we're in right now seems like a good time to do that, given that the code has now come into force. And as we said in the title, it's actually come of age. And I'm delighted to welcome Jacob Ohrvik-Stott to join us today. And Jacob is the acting head of regulatory features at the ICO. And I have to say, the last time I came across that title, it was someone I met who was actually working on a futures desk with an investment bank. And I'm pleased to tell you, we've not made a mistake here. That's not Jacob's role with an investment. Jacob really is with the Information Commissioner's Office. So I'm going to hand over now. That's probably enough of an introduction and a preamble from me, but I'll hand over to Jacob to introduce himself. We're delighted to have you here, Jacob, and over to you. Thank you.
Thanks very much, Vin, and yeah, thank you all also for joining. Really looking forward to discussions in a second. As Vin says, I've got a slightly abstract and possibly ridiculous job title of acting head of regulatory features. So in practice, that means that I split my time between leading our work on the children's codes and then increasingly as well thinking about how we can do sort of forward-looking anticipatory regulation and do things like horizon scanning to think about the changes that are coming down the track that the ICO might need to respond to. But To return to and start with the Children's Code, I think, as I've said, we're going to have plenty of time for discussion, but prior to that, I thought it would be helpful to give you all a quick refresher on the Children's Code, give you an update on the sort of milestones that we've hit already, some of the guidance we've produced, things like that, and the current context. I'm also going to do a bit of a deeper dive into some of the support that we've developed relating to the code for industry as well, which should hopefully speak to one of the sort of last pie charts that Vin spoke about the support that could be provided by us for you all. And then I'm going to wrap up with what the sort of next 6 months to a year looks like for the code and the road ahead for us before going into the Q&A. So to start with, a refresher on the Children's Code. The code is very much what it says on the tin. It's a code of practice which applies to online services likely to be accessed by children in the UK. And I think it's worth saying that if that phrasing sounds quite broad, that's because it was intentionally chosen to be so. Parliament, when they were laying the code, deliberately went with the wording likely to be accessed by children in recognition of the fact that lots of children on a day-to-day basis use services regularly that aren't necessarily designed for them, but are still very much appealing to them. And so in practice, the code covers websites, apps, online games, connected toys and devices, digital wearables, and a range of other things as well that are likely to be accessed by children and are commonly used by children. It's worth saying as well and reminding people that the code in itself is not a new law. Its role is actually just to articulate how the UK's existing laws, and in particular the UK GDPR, should be followed and interpreted in this context. And actually, in particular, the code articulates what it means to process children's data fairly. The code is grounded in the United Nations Convention on the Rights of the Child. The UK, as a nation and as a sovereign state, has duties to pay attention to this when it's making policies. And by extension, as an office, we have to have sort of general regard for it in our work as well, and to make sure that what we do respects children's rights under the UNCRC. And so we felt that it gave a really good sort of holistic framework to ground the code in. And actually, the overarching vision of the code, which is that the best interest of a child must be a primary concern when using their data, is grounded in one of the articles of the UNCRC, Article 3, if you're interested. And the UNCRC is sort of a golden thread running elsewhere throughout the code as well, which is comprised of 15 interlinked, sort of mutually supportive standards. The standards cover a variety of things. So some of them just touch upon sort of what I would call core principles. So one of the standards is around the best interest of the child and what that means, for example. Other standards in the code touch upon areas that are more sort of related to service design. So things like the transparency standard, which talks about how privacy information and choices should be designed for children to make sure that they're sort of age appropriate and accessible. Other standards like the nudge technique, for example, say that online services can't design their user experience in such a way that it is privacy eroding for children. So they can't, bombard them with nudge techniques to encourage them to give up more of the data than they would do otherwise and stuff like that. And then there's a final bucket of standards within the code which sort of cover areas where common data processing may pose particularly high risks to children. And that sort of assessment is based on just our experience as a regulator, and then also some of the evidence that we received during the consultation for the code as well. So the kind of activities I'm talking about here are things like profiling, which has its own designated standards, and other areas such as data sharing and connected toys and devices and things like that. So the code is quite broad. It's quite a holistic look at the online world, and it aims to give children a very sort of broad and holistic set of protections in terms of how their data is used. So just moving on to where we are at the moment and the story so far. The story begins a bit before 11th of June 2020, to be honest. There was a lot of work and a lot of discussions that we participated in around what the code should look like. But in 11th of June, the code was finally formally sort of laid before Parliament. Alongside that, we had to deliver an economic impact assessment of the code's impact on industry and others to government. That, alongside the parliamentary scrutiny, was completed in summer last year. And so in September last year, we began the code transition period. So as many of you will already be aware, the code transition period was a 1-year period to give us and industry and other stakeholders as much time as possible to prepare to conform with the code. And we opted for a 1-year transition period as that was the maximum possible that we were allowed to give. And we went for that in recognition of the fact that we hope that the code will be very transformative for online services. And so we wanted to give them as much time as possible to prepare and for us to work through the code's implications with them as well. And as Vin said during his opening remarks, at the beginning of this month, we reached the end of the transition period. So I won't sort of preempt what I'm going to say in terms of the road ahead, but we're now sort of shifting our attention away from sort of collaboration and guidance development towards more sort of supervision. Although the caveat there is that our engagement doesn't stop and we will still be available, to help people work through the code and things like that elsewhere. So that's a whistle-stop tour of the history of the code and where we're at today. Moving on to our support for organisations that we've developed through the transition periods. We've done a lot of things, and these bullet points or items that I mentioned here are probably the sort of headline pieces, but we've got other bits and bobs in our Children's Code Hub, which is easily accessible from the ICO website as well. So feel free to check that out. But in terms of the flagship pieces of support, we've got the Best Interests of the Child framework. So this is a sort of interactive toolkit, I guess you could say, that helps people to explore the UNCRC, the different rights that children hold under it, and then sort of understand and travel from there to how different uses of data might impact on these rights. And so it helps people to understand what the sort of fairly high level concept of the best interests of the child means in practice and in a specific way as it pertains to sort of individual rights, like rights to well-being and development, rights to access to information, rights to play, and things like that. We also have a suite of example data protection impact assessments, which are grounded in 3 hypothetical examples for services that are likely to fall under the code. So we've got one that focuses on an online retail example, we've got another on gaming, and then finally a connected device as well. The third bucket here is just sort of around a broad explanatory content. So we've got a range of sort of deep dive blogs into some of the specific code standards, some recordings of some intro webinars for people that just want a sort of 101 on the code, a range of industry case studies, for example, around how some stakeholders have used the Best Interests of the Child framework and things like that. And then we've also got 2 commissioned academic articles as well. So one of those articles is about the UNCRC in general and the history of that and how it applies to private organisations. And there's another one around sort of what detrimental use of data means in practice. We've got FAQs, they're what they say on the tin, frequently asked questions, including some specifically for the news media and edtech sectors. And then finally, beyond the sort of core work that I've been leading, we also have a range of formal support schemes as well. So the ICO Sandbox is a scheme available to applicants who are looking to innovate using data. We work with those innovators to help them understand how to develop their products in a way that complies with this protection law, and in return we get to make sure we can influence these innovations upstream to sort of make sure that they are as compliant as possible and that we can sort of share learnings with the wider sector and things like that. Beyond the Sandbox as well, we've also got a general business advice service. We've got an SME hub as well for smaller businesses. And then finally, we have recently approved a couple of certification schemes. So one of those certification schemes is for the UK GDPR in general, but that's also complemented by one that's Children's Code specific. So interested organisations can go through those certification schemes and get themselves certified to sort of demonstrate that they do comply with DP and the code as well. So do check that out if that sounds of interest to you. I did just want to spend a bit more time on our design guidance as well before I finish up on what we've got planned for the road ahead. So this is a final bit of sort of flagship guidance. It's some guidance that we developed in partnership with the design agency Big Motive. We developed it in quite an iterative fashion. So we developed prototypes alongside designers that work for a range of online services. We consulted with, I think it was 70 organisations in total, and people in the design and UX communities for that. And the end result of that was that we produced a series of design guidelines and patterns for people to think about how the code might look like in practice. So you've got here an example of some ideas to emulate, some ideas to avoid for the code and stuff. So what good and bad looks like. The design guidance also covers some sort of practical tools and artifacts as well. So we have some children's mindsets. So you can kind of think of these like child user sort of personas to give people an idea of what children across different age groups might need and what their kind of data protection risks might be that need to be considered. And then also we've got a workshop for people to do mapping of different privacy moments related to how children's data is used, which can then lay the groundwork for doing a DPIA and identifying risks and stuff like that. So that's quite a wide-ranging and really interesting bit of guidance. And again, I encourage you to check that out or share that with your design and UX teams if you think that's of interest. So just to finally wrap up before we move on to the Q&A with the road ahead, as I already said in my sort of beginning comments, we're shifting our focus towards supervision. So a few weeks ago in late August, we published a blog setting out our intention in this space. For the first 6 months from September, we've been clear that our immediate priority sectors concern gaming, social media and streaming services. And this is because our work through the transition period and our intelligence gathering efforts have indicated that these are areas where the risks arising from children's data use are probably highest. In practice, what we mean by them being priority sectors is that we will be sending out letters asking certain companies of a certain size for information about their practices. We'll be looking at scoping some audits, and following on from that general continuation of intel gathering, we may then go ahead and sort of look to progress our enforcement action where we find concerns and things like that. After the next sort of 6 months, and alongside this first 6 months as well, we'll be gathering intel on other sectors, and we may then sort of scope further work in those areas as well after the sort of initial sprint. We also have some more detailed guidance on age assurance and age appropriate application in the pipeline. So this should be published within the sort of next few months. I won't sort of preempt that because it wouldn't be appropriate to do so, but in general, what it will focus on is what it means to apply the age appropriate application standard of the code in practice. So that says that online services need to have a level of certainty about the age of the child users that's sort of broadly proportionate to the level of risks that arise from the data processing of those child users. And so we'll be giving a bit more information about how to interpret that in practice and what that looks like in practice. Although the transition period is over, that doesn't mean that our work beyond supervision simply stops. We realise that people have queries and will still need support. So we will be continuing engagement with industry, also civil society where they have concerns. We'll also be turning our attention to sort of international stakeholders and things like that, given the code may well be sort of setting an international precedent. And we've had sort of inquiries from other countries about what we've learned from the code and what we would recommend in that regard. And then finally, we've got our engagement as well with the DRCF, or the Digital Regulation Cooperation Forum, to give it its full title. So that's a forum where ourselves, Ofcom, CMA, and recently the FCA as well work together on cross-cutting digital regulation issues. And so as part of that, we've been working with Ofcom to make sure that the code works in tandem with their video sharing platform regulation. And that has sort of one eye on the online safety regime as well. That'll be coming into force and being enforced by Ofcom as well. So we'll be continuing the collaboration, we'll be continuing the engagement there. And then finally, the next sort of and remaining last bigger picture thing on our to-do list is to review the impact of the code. This was a commitment that we made to DCMS when the code was laid before Parliament, and that review is due in September 2022. So we'll be doing various activities to support that review, including sort of speaking to industry to see how they found the code and to see how they've experienced the guidance and support that we've offered as an office as well. So I appreciate that's a lot to take in. Thank you very much for listening. I think I'll just hand over to Vin now, and we can have a sort of open discussion about any of that and any sort of questions that you might have about the code.
Thank you very much for that, Jacob. That was really a fascinating overview that you've given us, and very important as well, just so we can understand and see, get a view of the journey now, as you're saying, and particularly the move from preparing to now it's here and moving into one, as you described, of supervision going forward. Just to reiterate to our attendees today, if you have any questions, please do use the Q&A function and send us your question. We'll be monitoring that. But what we've also done, as you may have seen from the invitation, is asked you if you wanted to send questions through separately and in advance. And we're pleased that quite a few of you have done that already. So we're going to start with the questions that have already come in. But in the meantime, please do fill in some questions, and we'll be happy to discuss those today. So let me kickstart with the questions that have already come in. And then we'll work through those and see how we're going on for time, if that's okay, Jacob.
Sure.
You mentioned legal design, and I'll start with that. And we've seen a lot of clients wanting to embrace this more and more. And there's huge advantages to doing that. We just can see how this is such a shift ahead in terms of addressing some of the fundamental requirements, particularly around transparency. So the question that's come in here actually relates to that. And I think it's a very interesting one because it strikes at the heart of lawyers and the role of lawyers in this as well. And the question is really acknowledging that there's a growing interest in using legal design to improve the transparency of privacy notices and communications, etc. Many lawyers may be nervous about replacing traditional language and layouts with very new approaches. And they might be nervous because of the fear of, I guess, inadvertently increasing their client's liability. And that's internal as much as external lawyers, I think, in this space as well. So the question in there is, will the ICO actively encourage organizations to move away from those very traditional non-legal design approaches of throwing lots of words at the problem?
Yeah, sure. I think this is not a new question for us. It's one that's popped up throughout the transition period. It's one that we've sort of been thinking about quite closely. I guess my sort of headline answer would be that I wouldn't necessarily see them as mutually exclusive. So it is perfectly possible and in the code sense desirable to have a version that is more legalistic, more sort of comprehensive and watertight, and then another version or versions that are more appropriate to children and their parents where possible. And actually the code acknowledges that online services shouldn't be really aiming to communicate everything to everyone all the time. And the Code Transparency Standard gives specific examples of this in that it says you should sort of provide options for children and parents to seek more or less detail depending on their level of understanding. It also says that you don't necessarily have to have all your privacy information in one place. You can have moments where the provision of privacy information is more appropriate. So, for example, at the point where, I don't know, profiling is about to be activated, you give them information in there. So the code sort of sets sort of broad aspirations for privacy information to be age appropriate and accessible, and isn't prescriptive about that. And I think we think online services have freedom to interpret how to apply that in practice to their privacy information notices as well.
And thank you for that, Jacob. And that, to me, strikes that consistency because legislation in this area over the years, and this is not new, has always, an interpretation and guidance that we've seen from the ICO has always encouraged the traditional in that, but also the non-traditional, and whether that's layered notices or just-in-time notices or a degree of dynamic being introduced into that conveyance of transparency and privacy notices information and how that fits in. So legal design is as we see,